Good morning, everyone. My name is Federal Postal Judge David-Wynn, Miller. And we are here today on a quo warranto complaint that was filed by Michael Morris Olson against the Internal Revenue Service. Two agents, Marie Maple and Deborah K. Hurst. The Kansas City Internal Revenue Service is where these women work out of, and the North Carolina Department of Revenue. They were all subpoenaed here today. We sent out green cards, certified mail, green card return receipts and summonses. Both I did as well as Mr. Olson did, and they were requested to come to a hearing today to give testimony as to why they created a fraudulent document to extort money. Now, we have the physical evidence with us, and this is my oath of office for Greensboro to have this court open today under Title 28, Section 636. The quo warranto complaint is the constitution of this room. Now, a court is a closed area. The closed area of the court is this document. It's a vessel in a sea of space. So therefore, the constitution of this room is ruled by this one document only. There is a constitution built into this document. The document is bonded together. It's stapled mechanically to hold it together, while the super glue bonds the document together. Now, bonded document, to have an authority, you must have a bonded book, hardbound book, and the hardbound book must have all the contents by the author advertising what the author's skill set is, his knowledge set, background, and the terms that will be used within a hearing. So this is a book I published, and it explains how these documents, how this quo warranto complaint was engineered in the first place. Now, the document deals with the correct sentence structure, communication, parse, syntax, grammar. Now, the mathematical interface on grammar was broken on the 6th of April, 1988 by me, and from that, this program was set up, and these books have been published, seminars have been put on now for 28 years on this technology, with 5 billion people worldwide on the internet monitoring the website of 400 pages, and the advertisement, as well as lawsuits that have been posted, over 12,000 on the internet, Lexis and Nexus. The document has a constitution built into it. The document has an autograph of the postage stamp, which has both Mr. Olson's name on it and my name, which is two or more people coming together, called a document contract corporation claim hearing. Okay, so the authority of how a hearing is set up, the last word in the sentence, I underline it, and it's a compound fact, has jurisdiction, and if I read it backwards, it's for the document contract corporation hearing of the level, same, plain venue is with the Title 28 Document Contract Claim Section 636 for the opening of this court hearing. So the document frontwards and backwards says the same thing. The terminology that is used in the book has full closure. That's why for the closure of the Miller-Federal-Postal-Court, who I am, my name, and the advertisement of the terms of the words are used in this document as well. The communications that I'm currently speaking to you in is written out in longhand in a study guide using a numbering system to identify 1 is an adverb, 2 is a verb, 3 is an adjective, 4 is a pronoun, 5 is a position, 6 is a loadial article, 7 is a fact, 8 is past time, and 9 is future time, and 0 is used as a conjunction, and is a command, and or is a option, or either. Now, we use a sentence can only contain 1 verb in it. The setup of a sentence has to be mathematically certified both frontwards and backwards, so no matter how many times you move the words around in the sentence, the value of the sentence and the authorization of that sentence is certified frontwards and backwards the same way as 1 plus 2 equals 3 and 3 minus 2 equals 1, or 2 times 3 equals 6 and 6 times 2 equals 6 and 6 divided by 2 times 3 equals 6 and 6 divided by 3 equals 2 and 2 equals 2 and 6 equals 6. So we add, subtract, multiply, and divide, or use sine, cosine, tangent. No matter what mathematical configurations in science we use, we can apply it to the same sentence structure, frontwards and backwards. A simple sentence for everyone to understand would be, for the bridge is over the water, for the water is under the bridge. Over and under are opposite prepositions, and both sentences are the identical picture. So each sentence that we create within the document of a quo warranto complaint creates an idea, a single idea, with a single verb, and certifies the value of all the words. So we can check the value of a sentence as we write it. So when we presented these points of information, and this technology has been advertised for 28 years, and the IRS has had 16 court hearings on this technology in the past. They are fully aware of the documents and how they are formulated, as well as the one that we presented or mailed to them, registered mail. Now, when the evidence that was bonded to the quo warranto complaint articulates the violations in styles. Now, the world has what's called the International Styles Manual. The International Styles Manual uses a same technology standard. What is an adverb? What is a verb? What is an adjective? What is a pronoun? What is a fact? How a position and loadial are used. Otherwise, communications between two foreign languages would be impossible. Commerce would be impossible without this. So we have standardized a communication in mathematical procedures, as well as the terminology that is used to identify those positions. We advertised it in the Constitution of this court so that everyone had an equal position to make an argument or to be heard at this hearing. The paperwork, as it was engineered here, was specifically engineered to be a zero or say nothing. They give no closure for definitions of words. They are using boxes on the document, and boxes create a closed area which nothing can be considered. Now, the Internal Revenue Service claims that they work for the United States Treasury. The United States Treasury is under the jurisdiction of the Post Office. The Post Office is responsible for all 3,850 branches of government. Because the Post Office was established on the 22nd October 1871, captured the entire world and all vessels. Now, paper is a vessel. Human beings are a vessel. Automobiles, trains, planes, all these things are vessels and how they move around the planet. But in order for anyone to be in control of a jurisdictional position, you must have a correct contract. If your contract is fraud, then your organization and the value of that organization is also fraudulent. So, and they don't give closure for the fraudulent use of grammar, even though we have a standard styles manual that is used by all countries for international communications, and yet they go ahead and they modify grammar and then say, you know what this means. Well, Nobody can understand or presume what another human being's mind conceives an idea, because you can't hold an idea in your hand. You can't see an idea. But you can take that idea and you can put it into words and put it on paper. Once it's on paper, if it's a fraudulent idea and fraudulent language, the syntax will then go ahead and identify the engineering volition of an individual's thought process. Now, under Maritime Law, Title 46, Chapter 1, Section 1, the first rule is closure. You must give closure for the volition of your contract. If there is a hidden meaning within your contract, and you did not advertise that hidden meaning, and it was used for subversive or criminal activity, then your contract comes under a terminology of a fraud. Henceforth, the fraudulent parse syntax grammar. Now up here, I gave you the definition of parse, which means it's parts of a word. PAR is part, and SA is with the meaning, or how you communicate. A syntax is two or more words with a connected meaning. You can say the word red, which is a fact. You can say the word pen, which is a fact. But when you say red pen, red becomes an adjective of the word pen, making red to be a color of opinion, and then the pen becomes a pronoun, which is subjective interpretation based on an individual's personal prejudice or opinion, which voids due process. So therefore, we must take control of the words we use and how we're going to put them together in a sentence. And a grammar is how a correct sentence structure, communication, parse, syntax, grammar, volition is used in a sentence, and a sentence can only have one verb. Now, a plane, when two people come together, they must be on the same plane in order to have a level playing field. That's why all sports games are played on a level playing field. Basketball, football, baseball. And the reason they have to be level is because of fairness between two or more people coming together, so they have equality. Paper is a flat plane. We write on a flat plane because the plane of the paper is the equal communication surface that we communicate with all over the world. In olden days, we used scrolls, which was a continuous piece of paper, could be 100 feet long, but it was bonded together as one sheet of paper. Today, we have, because of computer, we have 8.5 by 11 forms of paper, and everything is done by computers. So the governments around the world, because of the entire population voting to have a level playing field on paper and a standard of shapes and sizes of paper, they changed the rules that not a scroll is used, but we use 8.5 by 11. But then if you put it together, it must be bonded. Now we can write a document like this. It's some 28 pages long. And if we wanted to put this on a single sheet of paper, then we would reduce the points of print from 11 to 2. And we could write 25 or 30 pages of documents on one sheet of paper. You'd need a magnifying glass to read it, but it would be a bonded document. Henceforth, the terminology, read the fine print. So individuals, to make it easy, we write in 11 and 12 point print for legal all over our country as documents together in order so that it falls under the rules of bonding. Now paper, because it's bonded together, must be moved between point A and point B. That has to be paid for. A person's labor has to be accounted for, and compensation set down by the post office. So we use whole numbers, and a whole number is the postage stamp. Stamp is currency or equity value. So we buy a stamp for $1. We put a $1 stamp on the document, and by autographing across it, it makes us both the postmaster and letter carrier of this document to transport it between point A and point B. To make the stamp legal and its value, we then endorse the back of the top of the cover page the same way you endorse your checks at the bank, so that the autograph that is used, and we use punctuated autograph, certifies that you are who you are, and then we put a fingerprint that says that you are the individual, and that is an international notary that is accepted worldwide. And because a courtroom is actually an isolated area controlled by this document as the Constitution. So the Constitution of this room, when a judge says, I swear to support the Constitution, or I testify in the support of a Constitution of the United States, and they don't say of America, because America has nothing to do with what's in this room. United means we are no citizens. UN is no, and ITE is citizen. We are not an issue of citizenship on the outside of this room. We are the issue of two people coming together on a contract, and now we are bound, because this is a bonded document, because of the terminology used within this contract. We give closure for the terminology in this contract so it's fair to everyone. And the people, the IRS, when they were invited here, were given all the instructions in this document as to what was fair and equitable in this room, and this here would then become the Constitution of this room. The physical evidence of this document was specifically designed to be a trick. And so what we did was, I took in the evidence from the Internal Revenue Service, and I did what's called a syntaxing. I identified the words on the documents. Now, when we identify the words on the documents, we put numbers on top. Rather than write the word adverb on top of the word the, we use the number 1. And the next word here is provided. PRO is a prefix. Well, the prefix PR, AE, I, O, and U all mean no, because pre means to come before, which means it's the future. The future does not exist. So all words that start with a prefix, it could be pro, pre, like practice. The word un, in, on, all of your vowel in 2 consonant words mean no contract as prefixes. So you can look at a document and just count how many words start with a vowel and 2 consonants, or use a single vowel as a single syllable. That also means no. Now this comes from the Hebrew language, because the Hebrews don't use vowels in their grammar because it's a hollow sound or a negative sound, which vacates the meaning of the words. If you're writing the word no contract, you've automatically canceled the value of that sentence. So they have the Chinese, the Japanese, and other languages around the world use symbols. They have a dictionary of symbols, and the symbols have words assigned to those and are translated into the English language and other languages around the world. So they tried to get away from having fraudulent grammar used. Other languages take grammar and they put it together, sentence structure, and put it together, like the German language, as long words, but they're actually phrases. But to put an adverb in front of each phrase, turning it into a compound verb phrase, which actually creates 0. No communications of facts. So if you have a government that is setting up a specific engineered 0 times any number equals 0. 0 times any group of numbers equals 0. So a negative word of no contracts times any condition of facts within a document adds up to no contract. And they must give closure that they're writing no contract for you. If you still wish to participate, even though you know it's a no contract issue, it's voluntary compliance. So therefore, when we go to our schools only educate an individual to a 2nd grade reading level. That 2nd grade reading level translates into the identity of how courts and faiths communicate worldwide. And now when you think you're doing something correct, you're actually talking in a 2nd grade reading level. But if you put it on paper, we can then identify the conduct of how those words come together. If they were engineered to be a fraud, it will show up that there are no positional lotial fact phrases. Just using adverb, verb, pronouns, one right after another by double spacing the words between each other. And the word pronoun, P-R-O, means no, N-O means no, and U-N means no. If you have an adverb, ADV, or an adjective, ADJ, that's a vowel and two consonants. One is a modifier of thinking, the other is a modifier of fact. When you have two modifiers working together under adverb, verb, or adverb, adjective, pronoun, called syntax, you create nothing. You create a prejudice or an opinion. And by doing this, you vacate your authority or your facts within your documentation. So each one of these documents here, they use boxes to identify each column, but what's in the box is removed. So now we have numbers in a column, but the numbers are unidentified. So therefore they have no value. On top here, they say important release information. The word important, IM means no, P-E-O-R-T means to dock a vessel into a port or join it, and A&T is a contract. So it's a no porting contract. Release, R-E means no. L-E-A comes from, it means the word contract under value, and S-E is contract. This is calling parsate. That's how you break a word down. So you have no ported contract, no value contract, and information. In is no, form is the shape of the document, at is a location, and ION is contract. So you have no form, location, contract. So they're advertising to you that this is a blank sheet of paper, and it has no writing on it. But they say, pay this amount. Okay, now we have numbers over here, and these numbers have dollar signs assigned to them. However, the dollar signs don't have a definition, so you don't know where they came from or where they're going. They're a presumption of a number thrown out into space on a blank sheet of paper, and they want you to think that this is a value that you have to transport from your pocketbook or your checking account to an organization called the IRS. The IRS, internal, IN is no, TER is terra, earth, AL is contract, no earth contract. Revenue, RE is no, REN is venue, and UE is contract, no location contract or venue contract. And it's a system. So they're advertising to you that they're a nobody, a nothing. If I ask you to join with me, I'm going to use a word that starts with CO. You live in a community, a constitution, a corporation, meaning two or more people, a contract, two or more people. And I ask you to come and join with me. And I use the word C-O-M-E. C-O means to join, and M-E is contract, so join with my contract. But if I put I-N in front of the word come, I-N-C is a vowel and two consonants. Now I have no, I-N means no, come means to join, and me is contract, so no joining contract. So pay your taxes with the correct sentence structure for the communication, parsing, syntax, grammar, for the no income, or for the word income, which means no joining contract. See, if you use the word 3 plus 3 equals 6, that's a correct statement. 3 plus 3 equals 7 is incorrect. And here we have the INC, a vowel and two consonants, which now gives you a no correct statement. So pay your taxes on your no correct statement. This is a no correct statement because of the form that they're using, the words that they're using. The using word here starts off with as an adverb making provided. PRO is no, and VID is to see, visualize, communicate, so that you have a CPAS, sea treaty, and drogue law, so you know where you're going and how to anchor yourself. But they're using that as a verb, which is fiction. A position is a condition of state that puts you into a location, and you have to know where your location is, which is your drogue law. And then by, it says section, and then by is an adverb making section to be a verb. The numbers that they put after that section have no definitions assigned to them. Doesn't even tell you where to go to get these sections. And the sections, when they were looked up, are all written in adverb verb, so they have a number that's not supported by any value. Again, we have a no value, no contract, layer upon layer upon layer. The word notice of federal tax lien. Notice, N-O is no, T-I is title, C-E is contract. So they have a no title contract is a pronoun. It should say for the notice. So therefore notice is used as a pronoun. Of connects to the pronoun in front of it, now turning federal tax lien into an adjective pronoun. So federal tax becomes a coloring of the word lien, but then the word coloring violates the condition of state. They have to give closure for what the condition of state of each word is and use it in a correct sentence structure. If they wanted to make that into a correct compound fact must then be hyphenated. Now, the laws on hyphenation were established in 1834 by the United States Senate, Congress, and Legislature, which said any compound name of a state or a condition of state must be hyphenated, like New York, North Carolina. And when it says it's for the state of the North hyphen Carolina is the correct terminology. But your state in North Carolina here, because we're in Greensboro, North Carolina, just uses the terminology North Carolina, North being an adjective of Carolina. And when they say state of North Carolina, state is the pronoun, of is the adverb, making it to be an adjective pronoun. Now, North Carolina was ordered to be hyphenated in 1834 because the United States of America was the terminology used by the post office to join the states together under the Union of 1789, which was a bankruptcy trust, and North Carolina was part of the southern states. So the terminology of the North Carolina revenue, who were asked to come here today, failed to show up. We identified the condition of state of who they were, but the word America of is an adverb, making America a verb on the money. So if America, the 48 lower states of the Americas, is a verb, then all 48 states that are joined to that map of America must also be verbs. Henceforth, the hyphen had to be added to the name North hyphen Carolina, New hyphen York, South hyphen Carolina, to make it all joining under one venue. Now, under maritime law, to have a court, you must only have one venue. So, in the world of fiction, 3 plus 3 equals all numbers in the world but 6. In the world of correct sentence structure, communication, parse, syntax, grammar, we have to be correct so that 3 plus 3 equals 6. So we have to have the level of accuracy or correctness. Accuracy is the wrong word. Correctness is the correct word. Because accuracy is spelled ACC, which is no contract. When the government says you must be accurate, they're saying you must be no contract. And if you're no contract, everything they write is written in adverb, verb, and adverb, adjective, pronoun, or pronoun, adverb, verb. So henceforth, they're in a world of fiction. It's easy to be wrong in a world that 3 plus 3 equals all numbers except 6, creating one value or one venue of an error or perjury or fraud or mystic. And when you get into all the synonyms of what fraud means or fraudulent, it's very easy to get lost in the communications of nothing, taking all facts and turning them into a verb or an adjective or a pronoun. So we went outside that position. Now in the United States of America, United States codes, there are 4 billion codes written in the United States. Those codes, all 4 billion, are written in adverb, verb, or adverb, adjective, pronoun. They start with the words no person shall. No being a negative adverb, making the word person to be a verb, a negative verb. And if you were a dead negative verb, then you're a nom de guerre, and we capitalize your name. Shall is an adverb in future time, which means there is no now time jurisdiction for an illusion of no person. So henceforth, they're pushing everything into the future as a nobody. And no is an adverb making body to be an illusion as a verb. Therefore, they break the laws of factual identification again. So each one of these individual tax forms and the way they lay them out with these lines creating boxes. They'll use a serial number. The serial number is in a box which is removed. The name of Mr. Olson is used in a box so that he's not on the document, so he has no complaints. And the government comes back and says, well, that's just for convenience of not getting things mixed up. A constitution or a contract must be written in single spacing. All contracts, like mortgages or titles to property throughout the history of this country, dating back to July 4, 1775, use postage stamps on the documents. And all the postage stamps were signed by both the giver and the person accepting, as well as the judge who would rule over and make a determination. So they were using the stamp to move the vessel paper between point A and point B and make the operations of that act correct. Except Benjamin Franklin on July 4, 1775 went ahead and he wrote, "We the people." We was a pronoun, which is no, no, no. Thou was an adverb, making people a verb, which is fiction. And because he wrote "We the people" as a fiction, he created the Declaration of Independence. Thou was an adverb making declaration to be a verb. Of was an adverb making independence to be a verb. DE means no, Claire is speak, ad is location, ION is contract. Independence, in is no, D is no, pen is write, ans is contract. You shall not speak contract or write contract, but it will always be in verb, so it's a fiction. Because that was a violation without closure, and in July 4, 1775, the England Oversight Committee, their parliament, appointed Benjamin Franklin, who was a French attorney working for the English crown, as a secret agent to capture the United States. He was an attorney here in the United States, an English attorney or barrister as they were called back then. And therefore he wrote these documents. He took jurisdiction for script, which is writing contracts, and money. Henceforth the Postmaster General of the United States and Canada. And he was voted into that position because the people who voted him only had a second grade reading level and didn't know they were being hooked. It was an act of trickery by him without giving closure. So that act was a fraud. Now under Title 42, 1986, for knowledge of this fraud, Russell J. Gould and myself, a corporation of two people, went to the Philadelphia, Pennsylvania, which was the capital of the United States, on July 4, 1775, and filed this document to order the court open under Title 28, Section 636, and correct under Title 42, 1986, with knowledge of the correct parse, syntax, grammar, mathematically certified frontwards and backwards, and opened the court up, prosecuting both Benjamin Franklin and the England Oversight Committee under a quo warranto complaint for fraud against the American people, vacating his position, and then establishing a new July 4, 1775 Federal Postal Court. We then published these documents on the internet, as well as sending them to the President of the United States, the Supreme Court, the World Court at The Hague, the United Nations, the Congress, the Senate, and the Legislature of America, the State Department, and we gave them, and the Post Office, giving them closure as to the volition of a corporation taking over the Federal Postal Court. And this is our license and our lawful contract established 24 years before the United States Supreme Court was formulated under the September 17th, 1789 Constitution bankruptcy with England. And that was in 89, and it was 10 years later in 99 when the United States Supreme Court was formed, the Congress, the Senate, the legislature, and then they went ahead and they created the subcourts as federal district courts underneath them, and then the state courts and county courts and city courts, police courts, administrative courts, SOTRs to handle all the different things from a dog catcher all the way up to first-degree murder, rape, drug trafficking, all for public safety. Now, courtrooms were set up so that people had a neutral territory to give argument or to make their pleadings But because they were only limited to a second grade reading level for the last 240 years, the arguments made in the courts were controlled by attorneys, lawyers, barristers, solicitors, and everything was written in adverb verb to keep it in a world of fiction. They then divided the courtroom up into 5 different planes. Plane number 1 was the judge's plane. He was the highest position in the courtroom. Just like the deck of a sailing ship back in those days. The captain stood on the highest deck on the vessel. The next deck was reserved for the clerk of the courts, who was the secretary. The secretary then became the postmaster, who signed stamps, took money, and became both the postmaster and banker of the courtroom. When you look in Black's Law Dictionary or Bouvier's dictionary, and it says, for the word judge, it says see the banker and see the postmaster. When you look those up, it says see the judge. So the clerk of the court was the power behind the throne, being both the postmaster and banker, and the judge was an actor on a stage under Federal Rules of Civil Procedure 44 and 44.1. Now, all human beings coming to court were classified to be a foreign vessel entering a foreign vessel, because all the courthouses were elevated above the common land, but the courthouses were originally established by postal codes, because the post office was responsible for a vessel. So when a courthouse is built, it's a vessel in dry dock. Then there's a Title 46, Chapter 781 salvage claim established by the post office, and 1 year after the post office is established, then the court then becomes a court, a closed area for arbitration. That's why the sign on the building outside says the county courthouse and county post office, or the United States Post Office and court on most of your courthouses in North Carolina. If you don't believe me, go around and check them out. I have. So and back then it was the clerk of court, C-O-V-R-T, which means covert. It was Latin, which means secrecy. So they were hiding the secrecy of the syntax because everything was written in adverb verb. When an individual came into a courtroom, they were a foreign vessel. They babbled in a foreign language. They filed paperwork written in adverb verb, so therefore they had straight lines and curved lines on a sheet of paper called art, A-R-T. Art is an illusion of your creation or your creativity. When they spoke in adverb verb, they babbled. When they wrote, they babbled in adverb verb on paper. So the only thing that the judges could see in front of them, and a judge must have first-hand knowledge of what he's looking at, is a vessel trespassing on a foreign vessel in dry dock of his ship in dry dock that we refer to as the courthouse. And because there was no closure given, this whole thing was a venue of lies, a venue of perjury and tricks, traps, and illusions. And everything in a reflection of a mirror has 2 dimensions, height and width, but no depth, so therefore it becomes an illusion. Close your eyes, and the illusion disappears. So these are all terminologies that go back to Masonic teachings and how a courthouse or courtroom is set up to give an illusion that something is happening, but actually nothing is happening. Now, the third layer of a courtroom is your jury box. A jury box is an enclosed area. The word jury, J-U, means no law, and R-Y is contract. Because no law is spoken to the jury members, and the people babbled in front of a jury, they make sure that the jury is on... the jury box is laid out like this. So you have 6 and 6. And then you put a box around it. So it's an enclosed area and can't be considered. A 6-man jury is petite and violates the constitutions that were written. The Constitution of the United States expired on November 2nd, 1999, after 3 consecutive 70-year international bankruptcies. The United States of America Corporation now runs Washington, D.C., Guam, Virgin Islands, and Grand Samoa. Puerto Rico dropped out, so therefore there's only 4 countries now involved. The terminology that's used within the courtroom must be given closure, and the closure in this document says there is a level playing field, unboxed, with seating for 12 people, creating a grand council, not a grand jury. We have a grand council that will make determinations over cases. However, I am a federal postal judge for grammar only. The only thing I do is syntax, parse, syntax, grammar. We don't try cases for money. We don't try cases for stop signs or traffic or criminal activities in the world of fiction outside this room. The only terminology that is talked about in this document is grammar. Now, grammar controls all contracts. Parse, syntax, grammar controls the contract of the room, which constitutes your constitution or the contract between two or more people coming together. Because this is mathematically certified to be correct frontwards and backwards, it then becomes a clear advertisement giving full closure to Mr. Olson's ability to file a complaint and then take the existing forensic evidence from the Internal Revenue Service and use the styles manual, which are required by the Internal Revenue Service to communicate with Mr. Olson that they must be correct. Now, Mr. Olson will be commanded by me to pay his taxes to the Internal Revenue Service, provided the Internal Revenue Service can show a correct parse, syntax, grammar, law, rule, regulation, or code that gives them authority from the Congress, Senate, and Legislature, or the Supreme Court, Treasury, or the Post Office of the United States. If the United States has any correctly written documents that authorizes all these different departments to function together using the correct parse, syntax, grammar, with a correct oath of office written in the correct parse, syntax, grammar, to articulate their authority to appoint agents. The word agent, A means no, of gent, which means man. So therefore there is no man. It's an illusion. So the agents must have an oath of office in order to say they work for the Treasury. The Treasury has to have an authorization to create the IRS in the first place. If the contracts from the IRS and from the agents are both fraudulent, the forms that they're using are fraudulent, and they've been syntaxed, each one of them, with using the number codes and advertised on every single document. We have articulated the value of each one of these documents, and we have syntaxed the quality of each document and the tricks and the traps used when the government writes documents. They will use double spacing. They will use adverb-verb writing. They will make presumptions, putting in double spaces to void the continuance of evidence between one idea and another idea. But if each idea is certified to be a fraud, double spacing of fraud between each other is still a fraud. Any number times zero, or any group of numbers times zero, still equals zeros. Any group of words times an adverb, verb, or no contract word means no contract. And so therefore they're advertising they have no contract. They're advertising that they're creating an illusion on the document. Here it says amount due. A is a single vowel because the word mount means contract. So it means no contract. So they're advertising no contract due. Doesn't matter what they put after it. They're using the wrong terminology, and down here they put a number, but they put it in a box. Anything in a box is an enclosed area and can't be considered. So each one of these documents, as they have been syntaxed and presented to the Internal Revenue Service for a correction, they were asked to come here today to answer why they did fraudulent conveyance of language. Now, on March 1st, 1997, as a federal judge, I went into filed a lawsuit against the Treasury, and the Treasury went ahead and they issued new money on July 1st, 1997. Wrong one. Now, I sued the United States Treasury under maritime law of boxing. And what I'm going to show you next is that the $1 bill has a black line around it, 1997. That line that goes continuously around creates a box on both sides of the paper. So anything in a box is an enclosed area, which makes it void. And because it was a void sheet of paper, and here's a 1960 $50 bill, and as you notice, there's also the same black line that goes around that $50 bill. Well, after that lawsuit was won, here's a 20 and here's a 50, they have the boxes removed off the back, and there's no boxes on the front. They have decorative front, but they break the continuance of the boxing on several different locations within both sides of the bill, so they don't void the value of the bill. However, the grammar used on the bill is still a position of fraudulent conveyance of language. And so we're working on getting that corrected with the government, with the new money that's going to be printed by the government. If it was important enough for the United States Treasury to remove the boxes off the money because of international currency, which is used by 150 countries worldwide, then why did the Treasury still authorize the use of boxing with the IRS to collect money and then put fictitious conveyance of language on the documents, which says nothing? So again, we have a double standard here where a Treasury says the money has to be in a correct format and remove boxes, and yet takes and puts boxes on the paperwork that they correspond with us, and they take the value of their numbers and they either do not place a dollar sign in connection to the numbers, or they put the numbers in boxes so that they are removed from the paper as a void state. With that said, again, I iterate that the commands that I'm issuing with the Internal Revenue Service, as well as with Mr. Olson, is he must pay his taxes to the correct sentence structure, communication, parse, syntax, language, laws, rules, regulations, and codes that are created by the government who creates the money, the taxes, the IRS, and if they do not have any correct grammar, then he will save his money, and when the time comes that the government does have correct grammar, the taxation board has correct oaths, has correct parse, syntax, grammar documents, at that point, that will start a correct taxation system, where the agents have an oath, the government, the Congress, the Senate, the legislature passes laws, the president passes laws, the Supreme Court passes laws, that the grammar is correct, and now the people are giving full closure with the definition of the words to participate in a taxation system. As long as the system is modified and written in adverb verb fiction, that's an act of perjury, false and misleading statements under Title 18, 1001, fictitious conveyance of language, and false and misleading statements under Title 15, Section 1692E. The conduct of this document carries a $25 million fine under Title 15, Section 78 FF of the United States Codes, but the word United means no citizen, state, codes section. So therefore, because the United States Codes is a fictitiously conveyed language. This, on the other hand, is a document. So this is called a document contract claim section codes. And then we identify what the law is on this document to participate using correct language so that there is closure for his participation to pay money to an honest and a correct fact organization of taxes to support the government. So the command will be written for him to pay his taxes to an organization that is correct. But until the organization is correct and produces a correct document to stop and correct the wrongs under Title 42, 1986, my authorization under Title 42, 1986, as I placed it on the board here, is an advertisement that says that this room is a room where the fraud was brought to trial, the fraud was explained, the conditions of the courtroom were explained, I gave closure to everyone, and that they have to use correct grammar, correct parse syntax grammar, if they wish to collect money from Mr. Olson. Now, this lawsuit is conducive to this room only. It's a contract for this room only. It's the constitution of this room only. It's a case-to-case basis because he has firsthand knowledge of the continuance of evidence of a fact. I have firsthand knowledge of the continuance of evidence of the fact. And so the rules of the command of my decision-making here and issuing a command that it be obeyed is based on just the Constitution here. It doesn't affect the people who watched this document. It doesn't affect the people who are outside this room. Each individual who wishes to make the same argument that is on this piece of paper must file their own claim against their own personal knowledge of what a fact is and what the crimes that were committed against them are. Because someone else cannot use his case because there's no continuance of evidence. They're not here today. They weren't damaged by the people who participated and autographed these documents. The people who autographed these documents chose not to come. They chose not to speak. They were given an opportunity, a time, a place. They were given certified mail to appear here today, and they chose not to come and give arguments and answer the question, why did you modify grammar to extort money from Mr. Olson? So therefore, because they chose not to participate, the order, the command of this document stands. And so whatever claims they have against Mr. Olson, those claims are of false and misleading statements, fictitious conveyance of language, and a deprivation of his rights. So the command of this court is that he pays taxes when the correct parse syntax grammar, laws, rules, regulations, codes are presented to him in a form of a contract that he can participate with. And that's my ruling. Court stands adjourned.